The best of money matters. The big story.
Welcome to The Big Story. I'm Hongbin, Jeong. Watches worth more than some condos, handbags that could pay for a year's rent, and gold bars heavier than your laptop. Some of the 466 luxury items and 58 gold bars have been seized in Singapore's biggest ever $3 billion money laundering case. They include Patek Philippe and Richard Mille watches, diamond-encrusted jewelry, and Hermes and Louis Vuitton handbags. Now, these assets have been handed over by police to professional services firm Deloitte to manage and liquidate. So how does it actually work? Who decides how these assets are being sold? Well, joining us today to share more is Alexander Woon, who's a counsel of RHTLaw Asia, LLP, and Provost Chair and Lecturer of Law Programs at the Singapore University of Social Sciences. Hi, Alexander. Welcome to the show.
Hi, thanks for having me on.
Thank you so much for joining us. Well, Alexander, in a case of this scale where police have seized over $1 billion in assets, what legal processes must be completed before these assets, can be sold or liquidated?
Okay, so I think in the first place, it's not entirely clear to me just from the current newspaper reports what exactly the status of all the property is. So there's a couple of different concepts here. First, if it's evidence that a crime has been committed, right? It might be seized under the Criminal Procedure Code, in which case, after the case is over and the evidence is no longer needed, then it might be disposed or confiscated or forfeited, whatever it is. But there's a separate regime for confiscation of proceeds of crime. So maybe it's not evidence of the crime itself, but it represents the ill-gotten gains from the crime, right? In which case, there's a separate regime under a different Act of Parliament called the Corruption, Drug Trafficking and Other Serious Crimes Confiscation of Benefits Act, CDSA for short, right? So I'm just going to call it the CDSA, which might apply there. In which case, even if those assets aren't themselves evidence of crime, if they're ill-gotten gains, they could be confiscated and then forfeited to the state. So it really depends the exact nature of the property in question. And just from newspaper reports, it could be a mixture of the two at this point.
Okay, but how do the authorities assess if a seized luxury asset is, appropriate for liquidation rather than storage or even destruction?
Yeah, so that's a good question. And it goes back to that distinction that I raised earlier, right? So, for example, if it's evidence of a crime, right? Some kinds of evidence, it's obvious that you would just destroy it after the case is over. Like, say, drugs, right? You would just destroy those drugs after the case is over. Some kinds of evidence, you would return it to the owner. So like if you'd impounded somebody's handphone, you might, after the case, give it back to them. Now, in this case, well, there's a couple of things at play, right? Some of the items the owners have left, they've absconded, right? So they're gone. And some of them, they might not be evidence of a case. They might be ill-gotten gains, in which case they are confiscated. So they're forfeited to the state, right? So those things that are forfeited to the state, that are owed to the public purse, as it were, those are the things, of course, that will be sold off, and the value then will go to the consolidated fund. That's a process called realization.
Okay, then who legally owns and manages the seized assets during investigations and after convictions?
Okay, so ownership is not something counterintuitively that our system, which is called a common law system, really deals with. It's not that important. Ownership there are many degrees to it. So what's more relevant in this situation is possession. Who's entitled possession of those items? And if they are seized either under the Criminal Procedure Code or the CDSA, the police, right? The law enforcement authorities that obviously are entitled to possess them. Now, how exactly are they stored? How are they dealt with during the investigations? That's an operational matter for the police, and it depends exactly on the nature of the evidence, right? So if it's small items like handphones and stuff like that, it's probably kept in a warehouse somewhere. That's fairly simple. But the police sometimes deal with really big pieces of evidence that they store, like cars. So I know that at one point the police had a whole impound lot full of seized luxury cars and things like that as well. So during the course of the trial, the police will have custody of the exhibits, because at that point they are exhibits, right? After everything is done with and you get a court order for their disposal, then I guess it depends on how exactly they're going to dispose of it. Sometimes the police organize auctions, but I guess in this situation, it appears that the scale of the things that they have seized is so large, they've decided to appoint a third party to conduct the realization of those assets.
Okay, well, speaking of preservation here, what about in terms of the high-value luxury items, specifically to this case, such as the watches, the handbags, and gold bars? How are they stored and maintained to, preserve the value during investigations?
Honestly, I don't know. That's really an operational matter for the police. I'm not aware of the exact manner of storage.
All right. Well, then, can suspects or third parties legally contest the seizure of certain items? I mean, how often do such challenges succeed?
Absolutely, they can, right? So again, we go back to the distinction between evidence that is seized under the Criminal Procedure Code and then proceeds of crime that are confiscated under the CDSA. Either way, there can be a hearing and the court can then decide. In the case of evidence that is seized, right, after the case is over, sometimes the court will hold something called a disposal inquiry. So it's a hearing to determine what should happen to these things. So for example, if the police no longer need your handphone, you can ask for it back. In the case of confiscated property, there would need to be some evidence that it is in fact proceeds of crime, so that it has to be out of proportion to your known sources of income. So there can be a court hearing in either case for the court to determine where the property should go.
Okay. Well, the police have formally appointed Deloitte and Touche Financial Advisory Services for the management and liquidation of the remaining non-cash assets. So from a legal perspective here, Alexander, why should the state appoint a private firm instead of managing these assets internally?
I imagine it's because of the scale, as I said, right? I mean, the police are not really set up as an auction house, right? They're not set up as an auction house. It's something that they do as a sort of ancillary thing, right? Their main focus, of course, is on investigations and enforcement. And the scale, as is quite apparent, is unprecedented, really. I don't think anybody in public law enforcement is used to dealing with assets on this scale. So that's probably why they've done it.
Are there rules around who can be appointed and how they must operate then?
Yeah, so for the CDSA, the confiscation regime, there are rules about the court making an order for who should be the one in charge of the property to be realized. So there is a regime to do that.
All right, all right. Well, then, what legal obligations does a firm like Deloitte have when it comes to valuing and marketing these assets?
Again, those are all so if assuming it's all confiscated under the CDSA, all of those are then prescribed under the CDSA as well. So there is actually a legal procedure set out in the CDSA for valuation of those assets and duties of the person who's in charge of those assets as well.
Okay, but then once these luxury assets are approved for liquidation, where and how are they typically sold? I mean, who are the usual buyers of these liquidated luxury items, and through what channels do the sales occur?
That's a great question. I honestly don't know how it's going to happen in this case because usually police auctions are much smaller scale.
Okay.
So, there's usually a notice that goes out that, yeah, you're going to hold a police auction and then people will turn up. But in this case, it's going to be completely different because, again, there's another third party involved and it's going to be on a much larger scale. So I really don't know the answer to that. We'll just have to kind of wait and see how it turns out.
But are there, safeguards to prevent undervaluation or conflicts of interest? How are these enforced?
The way it's done is that the court would give an order for who is supposed to realize the property, right? And there would be terms of that order as well. So presumably, if you breach the terms of the order, if you don't do what the court tells you to do, then there could be legal proceedings taken out to enforce that. Generally speaking, of course, if you breach a court order, then that could potentially be contempt of court, right? And there could be separate proceedings taken out against you for that.
All right. Well, I mean, Deloitte will submit its proposals for the sale of the assets in due time, and the proceeds will be paid into the consolidated fund. So before we let you go here, Alexander, what is the legal reasoning behind this arrangement? And is there ever a situation where proceeds can be earmarked for specific uses like compensation?
Okay, so again, we have to understand the purpose of criminal law, right? So the purpose of criminal law is to punish people. It's not to compensate people. Compensation is really a function of private law. Why? Because you're using public resources to investigate and prosecute people. So anything that you get out of the case goes back to the public purse, right? And it's very difficult to justify using public resources to compensate private individuals. That said, there is a separate regime called compensation orders. So the court can, if it wants to, make a separate order for the accused person who is convicted of an offense to compensate victims who have suffered loss. But in this case, it might not be very clear who the victims are. It may not be very clear how to distribute out the proceeds. And in any case, the ill-gotten gains might not be from victims in Singapore. So if it's a just straightforward confiscation, which is separate from a compensation order, the confiscated assets will go to the public purse. As I said, because the rationale here is that we're just trying to deprive the criminal of his ill-gotten gains. We're trying to punish them and show that crime doesn't pay, essentially, right? The purpose of these proceedings is not actually to compensate victims. The purpose of these proceedings is really to enforce law and order and to deter other people from committing similar offenses.
Very interesting. Well, some great insights from you there. Thank you so much, Alexander, for joining me today.
No worries. Thank you very much for having me on. It was a pleasure.
Thank you. That was Alexander Woon, who's a counsel for RHTLaw Asia LLP and Provost Chair and Lecturer at Law Programs at the Singapore University of Social Sciences. This has been The Big Story with me, Hongbin Jeong.
To listen to more great interviews, download our podcasts at audio.sg or download the audio app. That's AWEDIO, audio at the App Store and Google Play.